Hello everyone, and welcome to the December 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. And for our last My PIP Monthly of the year, we will of course do a case law update. We'll be talking about two cases that kind of intertwine with each other. First up is going to be Auto Club Insurance Association v. Farm Bureau, and then State Farm v. Protective Insurance Co. And both of these cases somewhat deal with subrogation issues against two insurers and priority issues as well. Then we will move on to trending topics in PIP litigation and discuss the testimony of biomechanical engineers. All right, first up, Auto Club Insurance Association, also known as Member Select Insurance Company, the Farm Bureau Insurance Company of Michigan. Now, this case deals with MCL 500-3115. This is an action for recovery of personal protection insurance benefits payable under the No Fault Act for accidental bodily injury may not be commenced later than 1 year after the date of the accident that caused the injury unless written notice of the injury has been provided and the insurer and provided and given to the insurer within 1 year of the accident, or unless the insurer has previously made a payment for PIP benefits. And this is, of course, post no fault reform. This case also deals with MCL 600-5813, which states that all other personal actions shall be commenced within the period of 6 years after the claims accrue and not afterwards unless a different period is stated in the statute. So unless another statute of limitations apply. So basically those two statutes, the latter one is saying it's a 6-year statute of limitations unless, for example, the No Fault Act statute of limitations apply. Now, like I said, an insurer has 6 years to file a complaint seeking to partially recoup PIP benefits paid from an equal priority insurer, and that's MCL 500-3115 Section 2. But an insurer has 1 year to file a complaint based on subrogation from a higher priority insurer. Now, this is a situation that happens when there are either two equal priority insurers or one higher priority insurer, but the insurer that is seeking subrogation or seeking to recoup payments has already paid for a number of reasons for swift, because the No Fault Act entitles claimants to swift payment of their medical bills. So that insurer just thought it's better to just pay these bills than to fight it right now and then seek recoupment from that higher priority or equal priority insurer after payment has been made. Now, whether the 1 year statute of limitations applied or the 6 year statute of limitations applied, in this case turned on whether Farm Bureau was higher in priority. Now, if Farm Bureau in this matter was higher in priority, then plaintiff's action was a subrogation accident and MCL 500-3145 applied, thus barring plaintiff's claim. So here, if it's a subrogation action, then plaintiff only has 1 year. But if it's not a subro action, then plaintiff has 6 years. Now here, if plaintiff and Farm Bureau are an equal priority, then plaintiff can use that 6 year statute of limitations and obviously has more time. Now here, ultimately, the court found that the 1 year statute of limitations applied because it was a subro action and because Farm Bureau was higher in priority, and therefore Auto Club's claim was eventually barred, or obviously barred, because they have filed suit after that 1 year statute of limitations. Now, it's important to note that these decisions, whether which insurer is higher in priority, it's important to find this issue out or navigate this issue fairly early on in a case if possible. So here in this matter, what would have been a more successful outcome for Auto Club would have been possibly to deny payment and then seek a decision whether it was equal in priority to Farm Bureau or higher in priority early on, and then that would have saved them some money on the back end instead of paying the bills and then seeking to recoup payment. Because they did it that way, their claim was now barred because it was a subro action. Next up, we have the case of State Farm v. Protective Insurance Company. Now here I did want to give a brief background. On August 21st, 2019, plaintiff filed a complaint against defendant asserting that it had paid a substantial amount in PIP benefits to claimant, and because the vehicle insured by defendant was involved in the accident and shared the same priority level under the No Fault Act as plaintiff, defendant was liable to plaintiff for half the PIP benefits it had paid. Plaintiff further alleged that it was entitled to a declaratory judgment that defendant was liable for 50% of no fault benefits for the claimant's benefit. Now, the defendant denied all of the allegations here. Now, again, we have a case where an insurer, the plaintiff State Farm here, paid the benefits up front, but immediately sought to determine what insurer was a higher level of priority. Now, here, it's their opinion that the defendant, Protective Insurance Company, was at equal priority, but because they were looking for that equal priority, they were protecting their statutory limitations issues and just trying to get that deck judgment to determine equal priority insurers or 50% payment going forward for any other issues and trying to recoup their money. Now, defendant moved for summary disposition, arguing that because it insured the van, it was not involved in the accident and it was not obligated to pay no fault benefits. Now, plaintiff here also moved for summary disposition in favor of MCR 2.116I2 and argued that the court should award it costs, interest, and attorney's fees. Now, after the hearing on the parties' cross motions for summary disposition, the court ruled that the FedEx van was involved in the accident and defendant was liable for half of the PIP benefits, and this appeal followed. Now, again, we're going to dive into MCL 500-3114, Section 5, that says that a person who suffers accidental bodily injury from a motor vehicle accident that shows evidence of the involvement of a motor vehicle while an operator or passenger of a motorcycle shall claim PIP benefits from the insurers in the following order of priority. 1, the insurer of the owner or registrant of the motor vehicle. 2, the insurer of the operator of the motor vehicle involved in the accident. 3, the motor vehicle insurer of the operator of the motorcycle involved in the accident. And 4, the motor vehicle insurer of the owner or registrant of the motorcycle involved in the accident. Now, MCL 500-3114-5 is applicable when there's an accident between a motorcycle and a motor vehicle. Now here, as we all know, motorcyclists are not required to maintain PIP coverage, while owners of motor vehicles are required to do so. Now, motorcyclists are not required to maintain PIP coverage. The No Fault Act does nonetheless provide motorcyclists with the right to recover PIP benefits when they are involved in accidents with motor vehicles. Now here, this scheme of priority is important, and it's important to note whether this motorcycle accident involved a motor vehicle, because that is when the No Fault Act kicks into place. Now, here, defendant argued that the FedEx van was not involved in the accident because it was not an active contributor to the accident. The van was passively stopped and waiting at a red light when it was hit by Rader's claimant's body. Now, the court ultimately found that the FedEx van was involved in the accident, and therefore defendant is liable for half of Rader's PIP benefits. The court said that it was undisputed that Rader was ejected from his motorcycle and his body collided with the FedEx van. Now, because it collided with the FedEx van, obviously the FedEx van is a motor vehicle, and therefore a motor vehicle accident, the motorcycle and the motor vehicle were involved in an accident together, the motorcyclist. So ultimately, the Court of Appeals found that the trial court did not err when it concluded that the FedEx van was involved in the accident as a matter of law, and when the trial court granted summary disposition in favor of plaintiff. Moving on to trending topics in PIP litigation, I wanted to discuss the testimony of a biomechanical engineer and the admissibility of expert scientific testimony pursuant to MRE 702 and MCL 600-2955. Now, pursuant to MRE 702, if the court determines that scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact at issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise if the testimony is based on sufficient facts or data, if the testimony is the product of reliable principles and methods, and lastly, the witness has applied those principles and methods reliably to the facts of the case. Now, under MRE 702, the trial court must function as a gatekeeper in making decisions regarding the admissibility of scientific evidence and ensuring that expert testimony meets the rule standards of reliability. Now, this is what we oftentimes refer to as Daubert, and that is the case of Daubert v. Merrill Dow Pharmaceuticals, which is listed here. Now, MCL 600-2955 provides that an action for the death of a person or for injury to a person or property, a scientific opinion rendered by an otherwise qualified expert is not admissible unless the court determines that the opinion is reliable and will assist the trier of fact. Now, the standard for this, the court shall examine the opinion and the basis for the opinion, which basis includes facts, techniques, methodology, reasoning relied on by the expert, and shall consider the following factors: whether the opinion and its basis have been subjected to scientific testing and replication, whether the opinion and its basis have been subjected to peer review publication, and the existence and maintenance of generally accepted standards governing the application and interpretation of a methodology or technique, and whether the opinion and its basis are consistent with those standards. Now, while these two rules are somewhat similar, they have some vast differences. MCL 600-2955 focuses on peer review and generally accepted principles, but it also focuses on the following: the known or potential error rate of the opinion and its basis, the degree to which the opinion and basis are generally accepted with the relevant expert community, whether the basis for the opinion is reliable, and whether experts in that field will rely on the same basis, and lastly, whether the opinion or methodology is relied on by experts outside of the context of just litigation. Again, the MCL focuses a lot on peer reviews and the general acceptability of the method within the scientific community and not just in a litigation context. Now, in determining the admissibility of expert testimony, the trial court shall consider all the factors listed in MCL 600-2955. And as we saw there, that was a somewhat long list of factors that the court must consider. Now, the party offering the expert testimony has the burden of satisfying the preconditions established by MRA 702 and MCL 600-2955. So those two work together, and you can see why they work together. One primarily focuses on methodology, and one primarily majority focuses on peer reviews and the acceptance of those principles in the scientific community. Now, a court must consider all of these statutory factors in making the admissibility ruling, but evidence may be admitted even if some of the factors do not support admissibility. Rather, the pertinent determination is whether scientific opinion is rationally derived from a sound foundation. And that is citing the case of Chapin v. A.L. Parts. Now, there is some case law that supports what is not admissible testimony. Essentially, an expert opinion based upon only hypothetical situations is not permitted. But the law does require that an expert witness have a full understanding of every fact in a given case, only that it does not require that an expert have a full understanding of every fact, but only that the proponent of the expert's testimony set forth specific facts that would support a reasonable inference of a logical sequence of cause and effect. Now, in doing so, there must be facts and evidence to support the opinion testimony of an expert. Now, again, all of these factors work together to make sure that sound, scientific, supported material or opinions are used by experts in litigation, and not just someone saying that they're an expert on any given topic. Now, A good evidence of these factors is the case of Robin Harcraker v. Sheldon Hayes and B&M Ashman, Inc. This is an unpublished opinion, but here the plaintiff argued that a biomechanical engineer should have been precluded from testifying because she did not have a sufficient understanding of the factual circumstances of the case to provide a reliable expert opinion. Plaintiff also argued that the trial court erred in permitting the biomechanical engineer to provide expert testimony because she was not a medical doctor, but ultimately the court here disagreed. The court said that that the expert did not need a full understanding of every single fact in the case to be able to provide an opinion on several issues of the case, as long as she had a general understanding of those issues in which she was providing a scientific opinion about. And that is all I have for the final month of 2023. As always, my name is Amber Rouse Holloway, and I welcome any questions and or concerns. Thank you.